Hello, everyone. Welcome back to my YouTube channel. This is Lawyer Tina, and this is a channel where we learn about the laws of Ghana. We break it down so that everybody understands. And so, hey, if you are new here, just stay tuned. Today, we are talking about something that is called ADR, Alternative Dispute Resolution. So that is one of the fastest ways to resolve issues in our courts. So sometimes people say that, oh, when I go to court, the case lasts for like 1 year, 2 years. No. Sometimes within a month, you can go to court, you get what you want because you use what we call the ADL. Now, what is ADL? What are the processes? Who can get access to ADL? If you are a mediator and you are the one handling the ADR process in Ghana, what are you supposed to know? What are your duties? What are your roles? Is it compulsory? If ADR does not work out, what are the other options that are available to you? This and many other questions will be answered in this video. So when we talk about ADR, ADR is basically alternative dispute resolution. So it's a number of means that you can resolve your issues other than using the courts. So we have a number of them. We have what we call arbitration, we have what we call mediation, negotiation, even customary arbitration. For the purposes of this discussion, we are going to talk about Court Connected ADR. So this is basically mediation. So mediation is what is attached to our court system as the ADR that we are going to use to resolve issues within the court. So you can use arbitration, mediation, negotiation when you are outside of the courtroom. But when you come to the courts, and the court is referring you to a system within the court that you can resolve your issue through the ADL, the only ADL mechanism that we use is the mediation. I mean, you can opt to go and look for an arbitrator somewhere, but that one, it is not the court's connected ADL. I don't know if you understand me up to this point. So the court connected ADL is basically using mediation. It has mediators in the courtroom, and the courts will refer you at any time during the case, even before judgment, just before the judgment. Immediately you came, the first day you came, after maybe 1 month, after 2 months, either party can say that, oh, we want to go and try ADR, and say the court will refer you. Or the court by its own power can say, okay, I want you guys to go to ADR and go and try and see if you can resolve your issues. Or the lawyers may suggest that. Remember, if you go to ADL, it is not compulsory that by all means you should be able to resolve your issues. No. The court is of the view that when you go there, you attempt to resolve them. If it works out, hallelujah. If it doesn't work out, then you have to come back to the court. Now, can you refer every case to the ADL? The law says that if there are issues that are of public interest or something that is involved with the enforcement of the Constitution of Ghana, or a case that is related to the environment, these three cases, you cannot go to ADL. Now, there are also cases where it's a criminal case, but you can resolve it within the ADL system, but it's not all cases. There are some cases that the law sees that, oh, this one is up to a felony. It was grievous in nature. There are some specific crimes that the law would allow you to settle at ADL. If it's up to a felony, we have some classes of crimes. If it's up to a felony, the law says you cannot settle it at ADR. And then there are some of the crimes which are so grievous in nature that no one will allow you to go to ADR to settle it. So please take note of that. So offenses like defilement, rape, murder, manslaughter, hey, no, you cannot deal with this at ADL. But if you have an assault, something like assault, some misdemeanors, there are some petty things that we believe that you can resolve it in the ADL, and the court will refer you when they think you are capable to resolve it at the ADL. Now, when you go to the ADL, you have the mediator. The mediator can be one person, it can be three people. They will just sit there and they will act like referees for both parties. So there are three people in a case, or maybe there are four people in a case. Maybe it's a land case. Somebody said, oh, you've gone beyond my boundary. Oh, somebody said this. You sit down, then they will help you. Okay, what is it that you really want? How can I compensate you for the boundary that I have actually encroached? Oh, I admit that I have encroached. How can I? Then you guys will talk. Both of you will talk with the help of the mediators. It is not the mediator who is going to decide for you what to do. No, the mediator is going to help both of you to discuss the options that are available to you. Okay, that is it true that the boundary has been crossed? Oh, it's not true. Okay, let's go and check and see. They can go and check and see. If they realize that the boundary has been crossed, then we'll look for solutions. Okay, will you forgive the person? What are the solutions? Would you want him to pay some amount? Those are the discussions. Now, when you look at all the options, yeah, okay, I have accepted that I'm going to pay 1,000 cedis for maybe going beyond your boundary. Maybe the land is not worth 1,000 cedis, maybe it is worth more. But then just for peace to prevail. So all we are doing now is to try for peace to prevail between the parties. Now, after all the discussion and back and forth, if there's a need for an expert to be appointed, sometimes maybe you want to sell a property, it's a family property, and then you want to share it, but you have to sell it. There, both parties can agree for the mediator to go and look for an expert who will value the property and say, okay, this property is worth 10,000 cedis or 5,000 cedis. Now, it is both parties who have to pay for the services of that expert, not the mediator and not the court. Now, after all the discussions, there is an opportunity for the mediator to say that, okay, I want to talk to party A or party B in private. We call it a caucus. Now, that will help the mediator to talk to them and maybe draw their attention to something that they may not have drawn their attention to. They can do the same for party B as well. Now, the mediator is supposed to be fair. They are not supposed to be biased towards any of the parties. They're not supposed to take sides in the case. And so if you realize that the mediator has taken sides, you can complain and say, I don't want to be part of the mediation again. You can pull out of the mediation at any time. I mean, anytime. Just before you conclude the very beginning. Or you can say, I don't want this mediator. You can go to the courts or the registrar and say, I don't want this mediator. Please change this mediator for me. And they are supposed to do that for you, because we want the parties to be involved to select whoever takes care of the case, and that person who will be the mediator should be as unbiased, as fair as possible. Now, if both parties are able to make an agreement, the mediator is supposed to help you to write down, oh, we have agreed that one, this. Write timelines. Oh, if you're supposed to pay money, I'll pay it by December. Write it down. Then the parties will sign together with their witnesses. And then that will be sent back to the courts that, oh, we have agreed. And the court will accept that agreement as the final judgment. So you see, when you come to court, you want the judge to give a judgment. Now, when you make the agreement, you are saying that this agreement should be the final judgment between both of us concerning this particular case. So make sure you actually agree. Make sure you agree to whatever you have signed. Now, if you cannot read, make sure somebody reads to you for you to understand perfectly well before you actually sign your signature on that agreement. Remember that because the agreement you signed is for both of you, and we believe that both parties actually made the agreement without any force, without any duress, it will be hard for you to change that agreement on appeal. Now, this is very, very important. You must take note of this, because was a judge's judgment, then you can say I'm going on appeal. But now it is both of you agreeing. So it will be very difficult for you to go on appeal or for you to set it aside, unless you can be able to show that there was something grievous about natural justice, or maybe someone did not read to you and all of that. But it may be very, very hard for you to set it aside. So be very careful what you sign. And be very careful if you are signing something and then you know that it doesn't cover everything you came to court for. You have to tell the court that, you know what, when we went there, we were able to agree on this and that and that. But this particular one, maybe the land, we did not agree on the land, but we agreed on the rents. Make sure that you say the ones that you agreed on, because if you don't say it and it goes to court, it will be presumed that you have settled your whole case at the ADR. I don't know if you understand me. So if you went to court with maybe a landlord tenancy issue, and then the person also owes you some money, Now you have to let the court know that, oh, we have settled our landlord tenancy issue, but the amount of money he was supposed to pay me, he has not paid that one to me. So that you know that, oh, we're able to resolve some of them at ADR, but not all the issues. Then the court can handle the ones that you were not able to resolve. So please take note of that. The mediation process or the ADR process is a private process or a private proceeding. So you the parties choose who should be part of it. So you may go with your witnesses, but then if the other party is not comfortable with your witness, they will ask for that party to stay outside, and then both of you will have your negotiation or mediation before the mediator. So please take note. There are several advantages when you use ADR in the court system. It is faster, it is less expensive. Within a month, within 2 months, you can finish your case in court and you can get your money and your judgment based on the agreements. It is private. You don't need so many people there to come and see what you guys are agreeing on. And then it helps the parties to actually say all the things that they want to say in the process. So when you go to court, sometimes people say that, oh, I've been to court for 1 whole year, they've not listened to me, they've not said anything, they've not made me talk. Yes, the court procedure is a process. When you come there, sometimes a whole year you've not talked. It's just the judge talking and saying, okay, so we'll see you next month, we'll see you next 2 months. Then you've not even opened your mouth to say why you are in court, because the law is procedure. If it's not your time, you are not allowed to talk. But when you go to ADL, you are in a private room with this man who is not a judge, who is not a lawyer, but who is someone who has been appointed to assist both of you. That mediator allows you to free your mind and talk about everything. Maybe everything you wanted to say was not even written on the court document, but the court, through the ADR process, allows you to open up about exactly why you are in court. Experience tells us that sometimes the main issues why the person had come to court is not what is written on the document. So recently I heard of a case where a landlord was sacking a tenant because the tenant had impregnated the daughter of the landlord. When this landlord is coming to court, it's unlikely that he's going to write that the reason why I'm sacking him because he has impregnated my daughter. In the court, we may not know, but when you go to ADL, you can see all the wrong things that this tenant has done, including the fact that he has actually impregnated your daughter. And that is something that you may not be able to say it in the courtroom, because the court will not be entertaining some frivolous things. Yeah. So ADR also help us to save relationships between parties. So when you go to the court system, it's almost like everybody is fighting. I want to win by all means. I want to win by all means. But then through the ADL, you guys are able to sit down and say that I'm sorry and say I have forgiven you. And then you guys can go back and live together. And so especially for relationships, maybe for married people, for landlord tenants, for family relations, when you bring a case to court, it is most likely that we will refer you to ADR because we want to save the relationship between both parties. And then it helps to free the judges of a lot of cases so that they can handle the most important cases and the cases that cannot be resolved at ADR. So it's fast, very, very fast. ADR also helps by giving the parties the freedom to choose options for the case that they brought to court. Sometimes when you come to court, the only thing you say is that I want my land back, I want this, and that is what the court is going to decide on, whether you can get your land back, whether you can get this back. But then when you go to ADR, both of you are able to sit down and say, okay, I know you said you want your land back, but can I use it for 1 month time? Can I use it for 3 months time? There are several options, not just what you have stated on the court documents. So you can be able to think about better options that will suit both parties very, very well. Please take note that, of course, ADR has its own disadvantages. If you don't take care, the person that you have brought to court, if the person is more powerful, the person has money, they may have influenced the mediator, which is unlikely. But sometimes it happens. There are bad people. We are expecting that the people that we have trained to be mediators will be good people, and then they will not be biased, and then they'll be fair. But please be very vigilant. Be careful. Because we all live in the same community, it is possible that somebody may be influenced and may be acting in a very bad way. Even it may not be a bad way. You may think that the person is acting on your own interest, but it may not be the case. So please be watchful to make sure that the person is not being biased. If you realize the person is being biased, please say that you want to opt out and go to the court. Or speak to another person, speak to your lawyer and complain. If there's something that you want to complain to your lawyer about, complain to your lawyer about it. And then you can get some help. Remember that if you are going for the ADR and you are part of a group, maybe you went on behalf of your siblings, make sure you can discuss the options that have come up at the ADR with your siblings before you agree to them. If you are representing a company, make sure you are the director or someone who actually have a say in the company. If you just come and make decisions for a company and they do not accept it, you may have bound them for life and they may not have anything to do with it. So make sure you do not bind them when you know that that solution will not be accepted by all the parties involved. I know you have questions. Let me know what your questions are. ADR is very broad. This was specifically Court Connected ADR. I'll find time to talk about arbitration, about negotiation, about customary arbitration that happens in the chief palace and all of that. So if you have not subscribed to this channel, please subscribe, share, like the video. Let someone else also know about it so that we can all learn together. Until we meet again, please take care. And I am recommending ADR to you. It is one of the best ways to resolve issues at the courts. It will save you time and money, and you'll be happy you did. Thank you and have a good time. Bye.